B. Ivory Lamar has been itching to be one of the Loco lawyers for a week now. You could tell by the way he conducted himself in that trial, he was wanting to be on this list. And guess what? He finally achieves nirvana. He's going to be a Loco lawyer, finally. By the way, if you really want to know what Kyle Rittenhouse's trial would have looked like if John Pierce had stayed on or Lynn Wood had stayed on as his lead counsel, you saw it. The Theodore Edgecomb trial was a perfect example of what happens when you have an activist as your criminal defense lawyer. Okay? The outcome might have even been the same. But at any rate, Theodore Edgecomb took his L today. And by the way, he's not crying about it. If you think that he's all disappointed, think again. This gives him the perfect opportunity to get up in front of that microphone and cry about race relations. He's going to be in his element. I think he would have been a little disappointed if Theodore had been acquitted. That's just my theory. At any rate, we're going to watch B. Ivory Lamar. He's going to first cry about Kyle Rittenhouse, and then we'll watch him perform inside the courtroom. Hello out there. I am trying to get through.
With his powerful brainwaves cradled in the warmth of reasoning, it's time for Johnny Walker Dredd to straighten you out on a thing or two. Emanating all the way from exciting Las Vegas, Oklahoma, it's the Johnny Walker Dredd Show.
All right, B. Ivory, tell us like it is.
Drama that we've seen in the last year and a half in Kenosha all began. That was with the shooting of Jacob Blake by Kenosha police. That sparked the protests that brought Kyle Rittenhouse up here to this city in the first place. We want to bring in now B. Ivory Lamar. He's the attorney for the Jacob Blake family. Were you watching on television as the verdict was read today?
Yes, I was.
And what was your reaction? You saw how Kyle Rittenhouse reacted. What were you thinking?
Well, unfortunately, our response wasn't as surprising. I think when you have an illusion of what we believe justice to have occurred in this process, I don't think that you're really surprised about the outcome. I mean, you have 20 jurors that were selected in one day on a very publicized case. When you have that, you can't expect that there not to be bias that exists in the jury pool.
This is called sour grapes, a sore loser. Up until the verdict, everybody was talking about how, Kyle's going to be fitted for prisoner uniforms and he's going to have a cellmate named Bubba. And they fantasized about all the horrible things that would happen to him. And then as soon as he's acquitted, well, it was no surprise. I mean, we all knew that, right? Come on, B. Ivory, take your L like a man. And by the way, this whole notion somehow that, they picked the jury really quickly, that biased the results. Why would that bias the results in the defense's favor?
So unfortunately, though I'm very disappointed with the outcome, and the Blake family shares that sentiment, unfortunately, it's not surprising.
Keep in mind that Theodore Edgecomb had a long criminal past, and he punched Jason Clearman right before the incident. He provoked it. And B. Ivory talked at length about how you can't hold that against him. But he certainly wanted Kyle Rittenhouse going to prison for life. So what's the difference? Race. There it is. It's all he cares about. And this is why I say that he doesn't care if Kyle was innocent or guilty. He wanted Kyle convicted because it would have represented a political victory. It would have shown that, those white kids, we can throw them in prison forever. Oh, he didn't do it? Well, that's okay. It's a white kid going to prison, and that's what they wanted. It's bloodlust. And keep in mind, he knows fully well that Theodore Edgecomb was guilty. He knew that Theodore blatantly murdered that man, all right? And okay, as a defense attorney, you defend your client. But he wanted Theodore Edgecomb released anyway because it would have represented a political victory. Guilty or not, he doesn't care.
Attorneys like to watch other attorneys do their job and offer their criticism. I want to give you the chance now to talk about how the prosecution in this case did its job. There were times, the opening, some of the legal analysts said that the defense did a far better opening laying out the case than the prosecution did.
Oh, we get to hear Ivory Lamar tell us how these other lawyers performed. Oh, this is great. It's good to hear it from an expert.
As you sit back and look, were there missteps by the state in this case?
I think it's arguable whether, things could have been done differently. I think that.
See, he's so pathetic. He can't look at Binger and Krause and how they performed and find anything wrong. He thought that they did okay. That should have told Theodore Edgecomb all he needed to know about the fighting skills of Ivory Lamar. Should never have hired him.
That it is important to recognize that there were certain limitations placed on the prosecution.
Yeah, it wasn't the prosecution's fault. No, it was that evil judge. Oh, but wait until you hear why he thinks that the judge was unfair.
We are all aware, the prosecution was not allowed to refer to the decedents in this matter as victims.
The prosecution wasn't allowed to call Anthony Huber and Gage Grosskreutz and Joseph Rosenbaum victims, right? But what about Jason Clearman? Did you have any problem with the prosecution calling him a victim?
Secondly, we also want to bring to the court's attention to note that Mr. Edgecomb enjoys the presumption of innocence. We believe that no one is a victim in this case until it is proven in a court of law. That simply has not occurred at this juncture. As the court has reiterated on several occasions, this case is not to be litigated at this point. And while the facts and circumstances in this case are very unfortunate, our heart does go out to the Clearman family, but Mr. Edgecomb, through such presumption of innocence, is as much as a victim as anyone else. The term victim crime scene is prejudicial. It would tend to be heavily influential by a jury who would likely presuppose which people have been wronged in this case. We would further caution that the court's usage of the term victim in open court or during jury instructions would tend to further violate due process because it's suggestive that the issue is resolved against the defendant before the jury gets to decide this issue. Finally, Your Honor, there's so many different synonyms that the state could use in place of victim. They just refer to Mr. Clearman as the decedent. He can definitely do the same at trial. And for those reasons, Your Honor, we would ask the court restrict the usage of these terms.
And keep in mind, even though Theodore Edgecomb has been found guilty, in his mind, Jason Clearman is still not a victim. He's an assailant.
I think, however, they were able to refer to other individuals as individuals like arsonists. And, when you're able to have that.
Yeah, okay, so let's suppose that Jason Clearman had just gotten off work from rioting and burning buildings down, okay? And then he attacked Theodore Edgecomb. Do you think that this guy would have any problems with the prosecution calling him a rioter or an arsonist? Really? Okay. You continue to think that.
That type of imbalance. I think there's a lot of things that could have been done differently. Personally, I think that this was more of a reality show than a system that can really be respected.
Right, because the performance you put on over the last week or so was not a reality show? Really? Okay, we're supposed to respect that? We'll talk a little bit more about that here in a moment.
As it relates to the way it was carried out. It also stems from, the defense, prosecution, the judge, and the jury. You have to look at all facets of it. And one thing that's I want to make clear is that as it relates to Jacob Blake, we want to make sure that the focus is not lost with Rittenhouse. This all started with the injustice that America watched when Jacob Blake was shot 7 times by simply walking away.
He's crazy, man. We were thinking that the gang needs a crazy guy.
That's right. Jacob Blake just simply walked away and he was shot 7 times. How unjust. Let's not mention a few things. First of all, Jacob Blake had a felony warrant out for his arrest. Number 2, he assaulted the police officers. Number 3, he pulled taser prongs out of his chest twice. Number 4, he tried to get into a car filled with kids carrying a knife. But let's not mention any of those things. He was just shot walking to his car. And you wonder why Theodore Edgecomb is now going to rot in jail.
You know, you don't see the Milwaukee Bucks canceling a game for injustice that they thought occurred for Rittenhouse.
Good, because that would be silly, and it was silly when they did it because of Jacob Blake. They don't have all the information in front of them. They don't know what took place. The Wisconsin DOJ did. They investigated, and they determined that, guess what? Officer Rustin Shesky was justified in shooting Jacob Blake that day. So, sorry, take your L.
You don't see the Green Bay Packers canceling practice. You don't see the NBA league, the NFL, the baseball league canceling anything under what they saw with Rittenhouse. But you did see that happen with Jacob Blake. So again, all the supporters who stood in solidarity with Jacob Blake, I think it's important that our mission and our intention to make a change in our society continues. And again, the work we have to do is something that we got to continue to strive for.
It's not an exaggeration to say that if Jason Clearman was black and Theodore Edgecomb was white, he would be on the opposite side of this deal. Nobody out there in viewerland is going to possibly disagree with that. The reason why he fought for Theodore Edgecomb is very simple. He's black, and that was all it took. Just to remind you, he wanted Kyle Rittenhouse convicted, even though the video shows Kyle Rittenhouse being attacked in all 3 of the shootings. But he wanted Theodore Edgecomb acquitted, even though Edgecomb punched Clearman first. Let that soak in. Okay, so Mr. Expert here, they call him up. How do you think the prosecution did? How do you think the defense did? Well, we're going to see how old Ivory Lamar did. Hang tight. The defense put a witness on the stand. He was a former cop who was going to do an investigation on the thoroughness of the police department in their investigation. This is a witness who had no business getting involved in this, and the prosecution is thrashing him. But here's where things got interesting. The defense was so asleep at the switch that the prosecution calls an objection on themselves on their behalf. Listen up.
You only saw one body cam that the defense asked you to take a look at. Is that correct?
That is correct.
Because that's the one they wanted you to talk about, right?
That question's not allowed, but nobody from the defense says anything. Listen to what the prosecutor does.
You know what? I'll rephrase that question. You probably can't speculate as to their motives.
That's called throwing the defense a bone. That's how bad things got for Ivory Lamar. And we move forward. For our next comedy sketch, we go to Ivory Lamar's closing statements. And here he's trying to make a great point about Jason Clearman's wife and her testimony. Unfortunately, it takes forever. And I have no idea what he was trying to accomplish here, but let's listen in. Let's give him a chance.
She said her husband
By the way, it's at the 46-minute mark.
told her to turn the corner because he wanted to talk to Mr. Edgecomb. But the video shows that she likely made an illegal turn from the middle lane to make that right turn.
Oh my God, she made an illegal turn. I wonder if the cops have taken note of this.
She also admits that Mr. Edgecomb was no longer a threat when he got back on the bike to leave.
Yeah, she's in the driver's seat of a car. Her husband got punched. She's not in any danger, but so what? That's not the issue here. Nobody is saying that she drove after Theodore Edgecomb out of self-defense. That would be a ludicrous argument. That'd be the kind of argument that B. Ivory Lamar would make if he was actually trying to prosecute.
That's important. That's important. I don't know if you recall when we stopped the video, and you probably were wondering, like, what are they doing? And, why is this point being driven so hard? Because we wanted to make sure that she agreed that Mr. Edgecomb was not a threat to her at the time he punched and got back on his bike.
Let's see here. When Kyle Rittenhouse was running away from JoJo Rosenbaum, he wasn't a threat then too, but I bet this guy's not going to cut him any slack. That's not the issue here, dummy. She didn't drive after Theodore Edgecomb out of self-defense.
And that's why we asked questions. He said, so he's in front of you, right? Yes. You see the back of him, correct? Yes. And at this point, he's not a threat to you.
Yeah, we get it. This is the third time you've made that statement.
She said, yes. That's important for a couple reasons. Number one, it shows that Mr. Edgecomb retreated, or the word that you're going to see in the jury instructions.
Oh, he retreated? You mean like Kyle Rittenhouse, the guy that you wanted convicted? Oh, I see how that works. Yeah, he did retreat. He can reclaim his self-defense rights if he wants to, but then he can also lose them. He can lose them by doing something really irrational and stupid, like pulling a gun out and just shooting somebody for no real good reason. That's the problem with your story. Fleeing from the Clearmans isn't going to exonerate Theodore Edgecomb.
He withdrew. That's the word that the state is not going to want you to pay much attention to. They want you to gloss over that fact. Withdrawal.
Because they want you to focus on things that are important. Like, did you really have to shoot Jason Clearman? That's what's important.
That's what it is. He got on the back. He got on his bike. He proceeded forward. He turned a corner. That's notice that's imputed to the Clearmans at that point. No doubt about it.
Now, does he now reinforce the provocation law? No, he doesn't. Because the provocation law in Wisconsin doesn't really support this.
The next point is she also admitted that she could have kept driving straight to go home.
I don't know if that's really much of an admission. Obviously, she made a right-hand turn because her husband got punched in the face, and her husband was telling her, hey, pull this guy over. I'm going to go out there and probably beat the crap out of him. She changed it later to like, oh, he just wanted to talk to him. I don't believe that. I think he was pretty pissed. But obviously, she made a right turn because Theodore Edgecomb made a right turn. We all know it. Everybody on the jury knows it. The prosecution even admits it. And yet he's going to belabor this point like crazy.
I don't know if you guys, members of the jury, I don't know if you recall. I don't see it here now, but we had a board that we referenced at a couple times in the trial. And in that board, we look, you turn right here, what's these locations here? And we asked, okay, so which way is home?
Oh, he's going to get the board for him because the jury doesn't know what a right-hand turn is. Everybody on the jury knows that she could have went straight and gone home. Everybody on the jury knows that she made a right-hand turn because her husband got punched. Whether he told her to make a right-hand turn or not, well, we could probably guess he did. But nobody is thinking that she made a right-hand turn to go home. She even admitted it. So why are you doing this?
And she testified that, this is the board. Thank you.
Oh, here we go. We're going to have the map here because we have to make sure that everybody understands that she made a right-hand turn when she could have went straight.
So you remember the board, but we asked which way is home. And here's Brady Street. Here's the intersection where the X is. One of the witnesses during the course of this trial placed the X at that intersection. That's important. And she testified that home was straight. That would be the direction to go home. So Mr. Edgecomb had already made his right turn already. He already made his right turn. That's not a dispute. You've seen it in video.
Yeah, it's not in dispute. Even the prosecution admits it because it doesn't let Theodore Edgecomb off the hook. We all know that they went chasing after the guy.
Decided to go take a right turn after Mr. Edgecomb, likely under direction of Mr. Clearman. So when the state comes up and they talk about, he's a cold-blooded killer. He's a cold-blooded. He's violent. He's all of this. Mr. Edgecomb at this point now, he punched somebody. And the question you have to ask, did he have a firearm at the time he punched the first time? Did Mr. Edgecomb have a firearm on his person the first time he decided to punch Mr. Clearman? Of course he did. Of course he did. If Mr. Edgecomb was a cold-blooded killer, why not take the gun out at that point and shoot at that time?
This is one of the most unpersuasive arguments you can imagine. The idea that, well, if he was a cold-blooded killer, he would shoot in cold blood every time that somebody smarts off to him. No, he had the gun with him because he knew that he could go around punching people, and if they dared to do anything back, he could just simply shoot them.
Why? Why not? He was upset. And again, we said at the beginning and opening, there's no justification for punching anybody. Mr. Edgecomb should have called the police, let the authorities handle the situation.
Oh, and one more thing. With Kyle Rittenhouse, who he wanted convicted, by the way, Kyle didn't shoot JoJo Rosenbaum at the first interaction. In fact, there's no evidence that Kyle even provoked anything with Joseph Rosenbaum. He certainly didn't punch him. But when JoJo Rosenbaum ambushed him, Kyle did not shoot him, just like Theodore Edgecomb didn't shoot Jason Clearman at their first encounter. But for some reason, Kyle running away doesn't mean anything to this lawyer, but it exonerates Theodore Edgecomb for some reason.
He should have done that, just as the Clearmans should have done so as well. The state asked Mr. Edgecomb yesterday, they said, when you came down that stairwell, did you know it was a police department right there? Did you know it was a local police department right there? You know when they were grilling Mr. Edgecomb? When he was nervous? The same question applies to the Clearmans. Actually, the Clearmans would have gotten there faster because they had a vehicle to get there.
So he's criticizing the Clearmans for not going to the police. But yet, if they had gone to the police and Theodore Edgecomb had been shot by the police, what would he be saying? Why did you go to the police? Don't you know that by going to the police, you get the police involved against a black man? That's like putting that man in danger. Who in here thinks that he would not have made that argument? And by the way, Kyle Rittenhouse tried to go to the police, and the people that he supports tried to stop him. Let that soak in. At any rate, this is an excruciating closing statement by any kind of counsel that you could ever imagine. And the jury was like, oh, God. He went on for, let's see here, 6.5 minutes to tell us that the Clearmans made a right-hand turn when they could have gone straight. And that Theodore Edgecomb didn't really shoot Jason Clearman the first time. 6 minutes. That's how long he dragged this thing out. For the next comedy sketch, we have Jeffrey Parr. Now, he's a witness who saw a part of what happened between Theodore Edgecomb and Jason Clearman. And Jeffrey's a good guy. You know, he owns a bar, or he's a bartender or something, and he was across the street when it happened, and he saw part of it. And he's here in court to tell his story. And believe it or not, Ivory Lamar actually doesn't do a bad job of cross-examining him here. He's gotten Parr to admit that he didn't necessarily see everything. Okay? And it would have been all good if he'd have left it at that. But he makes a tragic mistake here. That is loco beyond belief. Listen up.
Now, Mr. Parr, have you met with the state in this case in preparation of trial today?
Yes.
How many times?
Once.
Have you met with the defense in this case at all?
No.
Okay, no further questions.
Okay, it's a standard technique. Get the witness to admit that he's met with the opposing side and not yours. That introduces a potential bias, right? He's willing to talk to them. He's not willing to talk to us. Maybe he has a stake in the outcome, at least an emotional one. No problem there, but it gets weird. Listen.
State.
Did the defense ever ask to meet with you?
No.
So the reason you didn't meet with them was because they never bothered to call you up and say you want to talk?
Yes.
All right. Additionally,
The prosecutor says, oh, he can't believe his ears, by the way. He says, the defense never asked to meet with you, and the witness says, no. But that's not what the prosecutor thought. Listen.
we called you, right?
Yes.
I'm sorry, Grant.
We called you, correct?
Yes.
And had anyone over at that table said, Mr. Parr, we'd like to interview you about this, would you have talked to them?
Yes.
Would you have gone to meet them anywhere they wanted to go?
Yes.
All right. Now, we just
Okay, so he has said nobody at that table, and he's talking about B. Ivory Lamar's table, the people sitting there. And the prosecutor says, if one of those had asked you for an interview, would you have done it? And he says, yeah. Now the prosecutor is really confused.
even see the car chasing, right?
No.
That was what your friend told you, and that's what caused you to take a look and turn over and see, unfortunately, what you saw.
Correct.
Nothing else, thank you.
Okay, so now it's B. Ivory Lamar's turn. He's going to go up there and he's going to ask a question he should have never asked. If he had just stayed in his chair, everything would have been fine. But he doesn't, and it's going to get laughable really quickly.
Any additional cross?
You just indicated that you don't recall the defense ever reaching out to try to talk to you about your testimony, correct?
Mm-hmm.
Okay, so he's making sure that the prior testimony was right. Nobody from the defense ever tried to contact him. And this witness said, that's right.
Okay.
Yes.
Yes.
Okay. And you work at a car shop, don't you?
Yes.
All right. Do you recall Ashley Sheldon reaching out to you? Ashley, would you please stand up?
She didn't reach out to me. She just came up to my place of work.
Okay, so there's a girl sitting at B. Ivory Lamar's table, and she did contact this guy. Listen.
Came up to your place of work.
And she said she was in Milwaukee Police Department.
She said she was the
She said she was with the police.
Okay.
The judge is livid. Wait a minute. This woman who went and talked to you told you that she was from the Milwaukee Police Department working for the defense. Oh my God. That is
So loco, man!
And now the judge is going to go back there and see if he can straighten this thing out. So off they go. Notice that the prosecutor turns to B. Ivory, and I think he's saying like, dude, what the hell is going on here? Did you have one of your employees actually go and interview a witness under the guise of being a police officer? Okay, so now they go back and the questioning begins again. The judge is not going to do anything here. Unlike Schroeder, he would not empty the actual courtroom to yell at the attorneys, Schroeder would. He's going to go ahead and allow things to proceed. And then after the testimonies are all over, the jury leaves, and then he's going to tear ass.
I want to discuss that sidebar. I called for an immediate sidebar because the testimony that was just elicited by the defense was that their own investigator allegedly told the witness that she was a police officer, which would first of all be false. Secondly, be dangerous in terms of the presentation of this case. Who wants to explain that? Beyond that, for the defense, that potentially makes your assistant or investigator a witness. Your side, Mr. Ahmad, just elicited testimony in making it a big deal over who that witness spoke to and didn't speak to.
Check this out. Third field.
Mr. Lamar said, you didn't come and talk to us, did you? And then when the state followed up on cross, the witness, who's a lay witness who has no interest in this case whatsoever, said your investigator or your assistant who's sitting at the table right now, a blonde female, came and represented herself as a police officer.
Love it. He says, a police officer. This is a big deal.
Judge.
No, I want to hear from them first.
Fair enough, Judge, but can I at least, because the defense ends up finding out about the accusation about 2-3 weeks ago from myself. And
Which accusation?
What you're referring to. So if I can just briefly explain what occurs so you understand. So here's what happens. When we reach out to Mr. Parr, this is going to be in preparation for the first trial date. We met with all the citizen witnesses that we plan on calling. And we meet with him. And I asked him, I said, hey, has anyone reached out to you to talk to you about this case? Because just, wondering if that had happened. Sometimes the press does it. Sometimes defense attorneys do it. I just wonder if anybody had done that. He says, no, a detective talked to me. And I asked him, I said, what kind of detective? He goes, a Milwaukee police detective. A woman came over, and he was of the impression, because he said that he thought she was wearing some sort of vest.
Okay, this is really important. Remember, he is the prosecutor, so the police, in effect, work for him. And therefore, having police officers going out and interviewing people that are not under his direction is a serious problem for any prosecutor. It comes off as a rogue police cop doing his own investigation. And of course, that's always dangerous. And so he's now trying to figure out what's going on. Why is it that a member of my team, which includes the police department, is out investigating without my oversight?
And that this woman called him on the phone and said, you can come on down to, and what he was left with the impression was the station, or she'll come meet him. And he said, well, then come meet me. And if you come meet me, he's like, why would I go talk to the police if they're willing to come to me? He then says that a female who he couldn't remember the information of, we were trying to ask him to find the phone number of, then comes and talks to him. He goes, I told him the exact same thing I told everybody else. Same thing I'm, telling you guys. And she says, thank you, and walks away. His impression was that this was a detective. The reason I was so nervous about this was, A, I knew of no detective and had not asked a single Milwaukee police detective to go re-interview witnesses. So I was worried that there was potentially another interview out there that we hadn't disclosed to the defense. I checked with my detectives. They knew of nothing. The only blonde detective I checked with her. Wasn't her. She didn't do it. And then through some belief, we believed it was a defense investigator associated with the defense firm. And sometimes I could see that maybe they refer to themselves as a private detective or investigator, and maybe he was left with that impression. I contacted the defense. I said, hey, just so you know, Mr. Parr was left with the impression that someone that worked for your firm was a police department. They told me it wasn't anybody from their firm. They said that they had a paralegal who reached out, and that was it. I didn't know anything about actually going to the place. So my impression was that they were just trying to reach him. and I didn't think anything of it.
Okay, so the issue here is that the defense earlier told him that one of their paralegals had reached out to this witness, but Lamar asked if anybody from the defense had ever interviewed him, and he said no. So Lamar is getting a witness to affirm a falsehood. That's at least in the eyes of the prosecutor. I will say this, the prosecutor is a very ethical person. He could have made a lot of hay out of this.
You're not the Loco one.
And it was only Lamar's own stupidity that brought this thing to the surface in the first place.
This is like watching the British version of The Office. Like, it's funny, but awkward and sad at the same time.
Yes.
The reason I went along with my questioning was defense counsel's question of, well, you met with the state, you didn't meet with the defense, led me to believe that this wasn't someone with their firm. Because when I talked to defense counsel, when I talked to Mr. Ahmad, honestly, at the end, we thought maybe there was some private firm maybe trying to get some civil lawsuit that might be doing some investigation. He told me it had nothing to do with him. We knew it wasn't the Milwaukee Police Department. And then when defense counsel says, well, you never met with us, that would obviously include someone sitting at their table that they didn't meet with. So I was left in the impression it was someone completely different. I wasn't expecting them to then point out their own paralegal, and then that was unfortunately the answer that we got. So
yeah, that was really strange. Lamar went up there and confirmed with this witness that somebody at his table had gone and talked to him. That's when the prosecutor went, wait, this unknown person is actually on the defense's team. Again, Lamar and his big mouth. If he would have just shut up, none of this would have happened.
So that is the factual basis of how I came aware of it, and I let defense counsel know that whoever talked to him left him with the distinct impression, based on how they introduced themselves, that he was speaking to a Milwaukee police detective.
None of that alleviates my concern, because no one that's not an attorney speaks to the court. Mr. Ahmad, that does not relieve any of my concern. Everything the state just said heightens my concern. This was discussed. Now this comes in as a surprise. Your paralegal was just potentially made a witness in this case. And as you know, I'm not saying this occurred, but if it did occur, impersonating a police officer is a felony. Okay? This is not a good situation, and I want an explanation right now from the defense.
The defense is now in really serious trouble. There are two teams that are working here. There's Lamar's team and this other team. I don't even know who they are, right? So they have joined together, and this other team is now like, wait, what's going on here? They didn't send her out. They may not have even known that she was involved in this at all, but they're on the team. They're responsible.
Judge, as I explained in chambers, so Attorney Huebner had contacted me a couple weeks ago. We were discussing some.
The one that's just stood up there, by the way, in the black is the blonde that they're talking about.
Witnesses, and then he brought this up regarding Mr. Parr. At that moment, Ms. Sheldon was in my office, and I had her come in, and we spoke together, all three of us. It was on speakerphone with Attorney Huebner, and I told her no. She did reach out to Mr. Parr. I believe she had a brief conversation with him at work. She gave our own business card. We wanted to meet with him to come into our office. I don't think there was any follow-up. But Ms. Sheldon works with me and Attorney Nolan and Attorney Lynn, who all practice here in Milwaukee. We always identify ourselves as a modern associate.
Then the problem is you asked a specifically misleading question to the witness, because you and your co-counsel know, based on what you just said, that your investigator spoke with that witness, and yet Mr. Lamar led the witness into saying, well, you didn't speak to our firm, did you? Yes, that's exactly what was said. Because Mr. Lamar was trying to imply bias in that witness because he spoke to the state.
Okay, so I'm mistaken. The girl apparently works for the other team. And I guess there was some really serious miscommunication problems between those attorneys.
And not your firm. Exactly what Mr. Lamar asked was, well, you didn't come speak to us. Counsel, that's a problem.
We don't plan on making Ms. Sheldon a witness. We wanted to move on.
The state may want to call her as a witness now.
Attorney Huebner? And There are two firms involved, Attorney Lamar's firm and then our firm.
But Mr. Matas, you're a team.
That
Okay, that's like the head coach telling me he didn't know that the assistant coach was calling a timeout or vice versa. Doesn't work that way. We're taking a break.
Okay, so he's trying to invoke Lamar asked that question. We didn't ask the question. Yeah, it doesn't quite work like that. Now, this isn't bad enough. Wait, the next comedy sketch involves what? The same woman. Lamar is going to do it again because he's Loco. Okay, you thought it was bad, huh? Oh, you sadly underestimate the Ivory Lamar. He's going to turn up the Loco here on day 3. Let's listen.
I just was handed these documents. Reportedly, they're from a Facebook page. I don't know the relevance of them.
So Lamar just hands them some screen captures from a Facebook page of the victim, Jason Clareman. And by the way, I can call him a victim because guess what? Theodore Edgecomb was found guilty. Okay. So at any rate, somebody from Lamar's staff went on Facebook, found something they thought was really juicy, printed them, and then Lamar just hands it to the prosecution. You're really not supposed to handle evidence quite like that. But guess who performed the investigation?
Objecting to them.
Your Honor, on direct, Ms. Clearman just opened the door as to the peacefulness of Mr. Clearman. The relevance of the Facebook post show otherwise.
These Facebook posts don't show anything. First of all, counsel, start by identifying them.
He's just absolutely had it with B. Ivory. He's sick of him. He really wishes that the dude would just go away. Not because he's providing a good defense for his client. No, it's because he comes off as somebody who has not had adequate legal training.
Your Honor, it is the screenshot of Mr. Jason.
And who got these screenshots?
Oh, yes. Who got the screenshots? But B. Ivory doesn't want to tell him because he doesn't want to tell the judge, oh, it's the same one that identified herself as a police officer to one of the witnesses.
Loco! Loco! Huh?
Now watch B. Ivory Lamar. And by the way, if you're wondering where Theodore Edgecomb got his evasiveness from, he probably learned it from B. Ivory.
It's publicly available online.
Tell me.
It's publicly available online. That's not what the judge asked.
Who got the screenshots?
We got the screenshots.
Who?
He says, so we got him. Yeah. No, I think the judge wants a name.
Stop saying we. Who?
The defense counsel.
Stop. I'm into the
defense counsel. The judge is like, oh my God, what do I have to do to get a name out of this guy?
The paralegal Ashley just printed them out.
Ashley who? Then again, Ashley is a witness in this case. Step out for the rest of this trial. Sidebar.
Yeah, it's the same one. The judge can't believe it. He's thinking, you have got to be kidding me. Didn't we already have problems with her before? And of all the stupid things to do is to have her, of all people, going down and investigating and pulling down screen captures. You can't do that. Anybody that's going to investigate and pull down stuff off the web is going to have to be called as a potential witness. Because they're going to ask questions like, well, when did you pull this thing down? And did you do any manipulation of the images or anything like that? So having her do it was really, really a bad move. And of course, now that she's been nailed twice for being a potential witness, he throws her out of the court. So B. Ivory lost his paralegal, but it gets even better. Wait till you find out what they risked this all for. What do the screen captures show? It must be something pretty important, right? I mean, you're going to go up there and flail with this dude? It would have to be real incriminating of the victim, but not quite.
So-called potential exhibit. And I believe it's Ashley that's your paralegal. She is now potentially again a witness in this trial. She is out and not allowed back in the courtroom. You have twice made her a potential witness. Yesterday, there was testimony that she may have held herself out as a police officer. Today, there's testimony, potentially, that she, just within the last hour, with no notice to the state, printed out what are allegedly, what purport to be Facebook posts. In both cases, she might be a witness.
Starfield.
I was never intended on calling her. She just does some internal research. She's never taken any statements, never written a report. We never named her as a witness. She just assists us in collecting certain things like news articles, videos, things like that. Just be judge.
Right. Counsel, for situations like that, you should use an investigator, not an employee of your office.
You know, this dude also deserves to be a local lawyer. I probably should go ahead and devote another episode of local lawyers to this dude. I don't even know his name, but he's not doing very well here.
Mr. Huebner, can you address this, please?
Huebner, the prosecutor's like, oh man, do I have to? Really? I mean, why do you want anything from me? I didn't do anything wrong.
Well, Your Honor, I would just simply state that.
Use the mic. Neither side's using the mic. We all use the microphones.
He reaches for that microphone fast. He knows the mood of the judge.
Just put it away so that I can mumble. Judge, regardless of that issue, my point is I don't understand the relevance of two Facebook photos, I guess a slideshow of stating that other people may not like Jason, but the wife likes Jason. Like, I don't understand what the relevance of this is.
That's what they printed. It was his bio, and he had a little quote there, we probably won't get along. And the defense thinks that, oh, that proves that Jason Clearman is a murderer. I know. Actually, what they were trying to prove is that he's not such a great guy after all. But whatever. I mean, nobody's going to take that kind of evidence seriously.
I don't understand the relevance either.
Judge, the relevance.
I also don't understand how they're going to be authenticated. I don't know when they were taken off of Facebook, which again, counsel, is why your paralegal's now a potential witness.
What's the question?
What's the relevance?
So, Judge, Attorney Huebner elicited on direct that from the witness, at least she testified, he asked.
You know, I'm wondering if the lawyers could come in with some advice here, but would it be advisable if they just said, look, we're just going to go ahead and retract it. We thought about it. We tend to agree with the prosecution that this probably doesn't really tell much of a story after all. We thought it did at one time. We'd like to retract it and make this problem go away. Instead, they're going to try to affirm that this is really important. They know that this is not going to get Theodore Edgecomb off the hook. But, okay.
Asked her a question, then she answered, I think, a little differently. And she said that Mr. Clearman is a peaceful guy. He is into conflict resolution, something along those lines. And that, you know, the state's trying to introduce that he's a peaceful character. The statement, or not the statement, but the Facebook post just has one tagline which says, we won't get along. And that shows the name Jason Clearman. We probably won't get along is the exact language of that. And there's a picture of a gorilla. Now, as far as authentication, I think we could simply just ask her, and we don't need to show this to the jury. We can say, is this a fair and accurate representation of his Facebook profile? If she says no, then that's the end. We're not going to try to rebut that, and the jury doesn't need to see what it is. But
Oh, I see. So in other words, we don't have to worry about being able to authenticate the evidence. We could just go ahead and present it to the witness outside of the jury's presence. Oh, come on.
if she says yes, then she can confirm that that is what his tagline was, and that.
So what? Oh, yeah, that's his tagline. What's the relevance? You're not answering the question.
That's pretty much it. It's not really, we're not going to show it on the projector. We're just going to hand it to the witness.
Mr. Hubner.
See how a Facebook profile of him saying we might not get along has anything to do with character for peacefulness. There are plenty of people that I don't get along with that have never punched me or shot me in the face.
That stung. You know that had to have stung. I think Theodore Edgecomb got a bolt of pain right up his side on that one.
It says we probably won't get along. It's
Right, the one Facebook post, it looks like it might be. I don't know how to describe it because, as far as I'm concerned, Facebook is part of the downfall of society.
He's right.
And I'm not on Facebook, thankfully, but it looks like it might be possibly a screenshot. One that says, Jason Clearman, we probably won't get along. Then there's one that says, Evangelina Clearman, I, however, do get along with him. That's relevant how?
So when the judge says that's relevant how, you're probably suck at that point.
in terms of peacefulness, if you're somebody who just doesn't get along with others, if that's, the proposition that the Mr. Clear.
Well, first of all, you can not get along with people and still be a peaceful person. I mean, it means nonviolent, right? Just because you don't get along with people doesn't mean you're out to hurt them.
Clearman is putting on his own page, then I think it relates to, his peacefulness, or I think that's a jury question to decide, Judge, if he's a peaceful character or unpeaceful character. We've seen the video, so we're aware of some of the basic facts in this case and how this ends up happening. We've heard language as well. I think that since it's been introduced, I think it's fair game, Judge. If it wasn't, then I think the state would have a much stronger argument to exclude this.
I disagree. It's irrelevant. A screenshot of one Facebook post shows nothing, and your paralegal stays out. He's now a potential witness on 2 times. He's out for the rest of the trial. We're not discussing this anymore, counsel. We're not discussing anymore. I made my ruling. It's out. It's irrelevant. I'm sustaining the state's objection. Let's bring the witness back in, please.
My question is, this is Wisconsin. Why didn't B. Ivory Lamar and his crony there get a different judge? I mean, surely this man's reputation as hard-nosed, no-nonsense, not going to put up with your crap, litigation style preceded him. Why did you choose this dude? Well, I don't know. Wisconsin law, by the way, allows you to have one push on the judge. So in other words, the first judge that comes up, you can say, no, don't want him. You don't have to justify it. And you get the next judge, but you can only do that once. But I would have done it here. I mean, if I'm B. Ivory Lamar and I have no brains and nor experience in high-level self-defense cases, that's what I would have done. I would have got some pushover. But Lamar may not even know the law in that respect. So we'll do one more here, comedy sketch. However, over the length of the trial, Lamar put his foot in his mouth numerous times, and trying to detail all of them would consume a lot of time, so I'm not going to. So one more, and then we'll call it a day. Now, you may be wondering, what is the biggest mistake that you can make in a closing argument? You think about it a little bit, and then it dawns on you. And if you don't know yet, listen in. He's going to demonstrate.
And at the end of this defense presentation, we're going to ask that you find Mr. Edgecomb guilty on all counts.
Wait, what did he just say?
We're going to ask that you find Mr. Edgecomb guilty on all counts.
We're going to ask you to find Mr. Edgecomb, the man I'm representing, guilty on all counts.
Hi, I'm the most local person in here.
So B. Ivory Lamar finally makes the grade. He becomes a local lawyer.
With this bandana, I welcome you to the game.
That other dude at the table, hell, he's going to probably make a future show himself. Like my video and subscribe to my channel.